So we registered the 2 cases under the Gender Justice Court, and that is evident on the citation, because we felt we also needed to bring focus onto the victim. Mainly because our focus was also on the intimate partner relationship between Mr. Elvis and our victim. And in that particular practice erections that were gazetted in, I think it was in February last year, 2025, there were certain objectives and principles that needed to be met.
Your Honor, with kind permission, I beg to plead with this court.
Don't click the mouth, just talk.
I'm very sorry. Your Honor, I'm really worried as to the trajectory we are taking. I believe court gave directions that we are limited to what is in this affidavit.
Yes.
Allow me. If you allow me, you will see where I'm going.
Your Honor, we don't have the luxury of time to see where she's going.
You want us to be blind? Okay, listen to me, both of you. Ms. Kibunja, we all know why the Gender Justice Court was established. So let's just get to the affidavit as it is so that we see where you're going.
Yes.
Madam?
I think if counsel would have allowed me to proceed, I'm looking at paragraph 6. Huh?
Yes.
I'm looking at paragraph 6. We indicated that our victim is a vulnerable victim, and this was for the definition of the Victim and Protection Act, Section 17, and also the definition given under Section 2, defining what a vulnerable victim is. In fact, currently we have an evolving situation where we cannot even produce the P3 at the moment because her condition with regards to treatment and her health is currently evolving. But it has been put on affidavit, and that makes her a vulnerable victim and also a witness. Connecting that, we appreciate the accused's right to bond and bail, as has been given to him under the Constitution. However, we are also allowed to bring up compelling reasons as to why that needs to be denied. Now, if you look at paragraph 6, no, sorry, Your Honor, as regards to paragraph 5,
yes,
the IO was able to establish that even in remand, the accused has been able to make contact with the sister of the victim, not extending remorse, but more or less demanding a reconciliation between the parties, failing to consider the seriousness of the offense, which is a grievous harm to a party. Not only was the harm life-threatening, but it is likely to cause permanent disfigurement on the victim, Your Honor. In addition, what is coming out from the evidence, and that is the data that the IO has been able to get from Safaricom, and this has been also, I must admit, it has been a struggle to get the subscribers to comply. What has come out very clearly and has also been supported in the pre-bill report that was filed on the 14th is that this was not a one-off offense. Not only was there a pattern of behavior where there was escalating attacks on the victim, but also what has been established, and this has been brought out by paragraph 8, is that it is almost like a criminal network of people who sat down together, not only to scheme the attacks, but also there was financing of the attacks. There was someone who could transport the executioner, and then finally we had an executioner. Now the connection between the executioner and the accused who's presently in court has been availed in court.
Miss Kibunja, sorry,
Yeah.
just as a quote,
Yeah.
I want us to be very professional about this, again, out of abundance of
Yes.
what did you say?
Of caution.
If we go down that road,
Yes.
then it means we are already ahead of time. It means, just a moment, it means we are now talking about evidence.
Yes.
And you don't want it to be you don't want to be told that it's from the bar.
Yes.
So I don't know at what point we have the executioner, the financier, and the whatever it is, the network, because that is something that ordinarily should come out in evidence. I just want you to, in as much as you're going to say it, limit yourself to the affidavit so that we are not delving into the arena of evidence, because again, I doubt that you'll want to be put there and cross-examined under oath.
Yes,
Yes.
I totally understand and I respect where you're coming from.
Okay. Maybe you rephrase.
So limiting myself to
Yes.
paragraph 9,
Yes.
where as per the affidavit of the IO,
Yes.
he has said with his own interrogation of the evidence,
Yes.
it has revealed multiple conspirators.
Please let her know if you need hot, apart from Ms. Kibunja and prosecution. Yes?
And in his
It
position,
has revealed multiple?
conspirators
Yes.
that led to the attack on our victim.
Yes.
And not only does he fear there will be a compromise with the ability to identify, to trace, but also to apprehend the remaining suspects. I am just tying this phrase, Your Honor, allow me, to
Yes.
the pre-bill report,
Yes.
where the victim herself, and I'm sure, I think all parties have a copy of the pre-bill report,
Oh, they each have, and they've each submitted extensively.
where the pre-bill report indicated that the victim, even as she lay in her hospital bed, fears for her own life because she has had numerous interference by parties who claim to be one person or the other, either coming from the KDF or coming from the police, coming to interfere with her own peace of mind as she rests in Kenyatta National Hospital, Your Honor.
Yes.
These cases have already been reported,
Yes.
but that also ties itself also to the issue of interference of both the victims and witnesses.
Yes.
And Your Honor, I will just make a quick reference to a case.
Your 3 minutes are up.
Your Honor, I had 5. I have 2 more minutes. I will just be making a quick reference, Your Honor, to the case of Republic versus Hashim, alias Hashim Mohammed Khalif, and this was a criminal case of E082 of 2024, where there was an order given on bail and bond applications, where they denied to protect the victim family members, whom according to the bail report feared harm, and also protection of the witnesses, because there was proven interference by the accused parties, Your Honor.
Yes.
Yes. Our argument was that for as long as this annexed statement
Yes.
exists,
Uh-huh.
it is of interest to the defense and the accused person that it should not be linked completely.
Okay.
And as we are arguing,
It's just that suspicion.
that risk that since the network is yet to be finally
His
revealed,
network.
yes, and there are still multiple conspirators who are currently
Who are at
pursued,
large.
At large. If he's released immediately, there could be instances where that investigation process could be
Compromised.
That was our argument.
Okay. No, I got the argument. I'm just putting you to task because you have brought this document and I've allowed you to bring it late in the day so that
Yes.
justice is not only done but seen to be done, right?
Yes, yes, Your Honor.
Yes. That's it?
Yes, that's all.
All right.
Thank you.
Your Honor, this affidavit was the last nail that we were waiting for on their coffin of failing to give compelling reasons for detention of the accused person. Why do I say this? Your Honor, you have the affidavit with you. Number 1, paragraph 5 of the affidavit. I was kind enough when I last submitted on the 14th of April to lead counsel to 2 case laws on interference. The case of Dwight Sagarai of 2012 and the case of Michael Oyamo, the Wado case of 2024. At this point, I'm convinced that they didn't look for these cases. Your Honor, I'm going to reiterate, just because I'm still seeing this in this affidavit, that there must be material evidence before court. They attempted to mislead the court by annexing an unknown document. It's a document that is foreign to this affidavit, in an attempt to bring some material. Clearly, going through all the 11 paragraphs of the affidavit, there's no relation at all with whatever is annexed. Having said that, back to the affidavit. At paragraph 8, they talk about a lot of speculation and fears that they're having, trying their best to connect the accused person to any other person who might have committed this crime, but they have failed to do it. You know, when I indicated that we could even have submitted before having that break, I had looked at this affidavit. One of them alluded to a case, the case of Hashim of 2024. And they said that in this case, I believe it was the counsel who went first, that there must be proven interference. I believe she didn't notice that that would work against them. The question is there any proven interference in this instance? And the answer is no. All parties agree.